Oh my God, the things that Mexico is asking for,
They
Richard.
want to rewrite American gun law.
They do. Like, they want things that you could not do through executive order. They want things that the Congress could never get through. I
Or
mean,
if they got through, would be found unconstitutional.
yes. We are the Arms Attorneys. Today we are coming to you with our breakdown of the wildest Supreme Court arguments to happen to gun law in at least a couple months here.
Yeah.
We've got Mexico versus Smith & Wesson. We listened yesterday. We're breaking it down for you today. Stick around. We're going to talk about what they said, who we think is going to win, and what happens next. But before we get started, show your support for the Second Amendment by hitting the like button.
And quick announcement, if you are here in the state of Texas, especially if you're in the kind of greater Austin area, Gun Owners of America, Texas is going to be holding their Gun Owners Lobby Day. This is taking place on March the 11th at 10 a.m. at the Robert E. Johnson Conference Center. Now, go on Gun Owner. We'll have it linked in the description below. Gun Owners of America, Texas's website. They're actually running buses from all over the state. So hitch a ride with a bunch of fellow patriots. Come help out and advance Pro 2A legislation here in the state. And we'd really like to hang out and see you. But going back to Smith & Wesson in Mexico, just listen to the oral arguments in this case, and I'll say, just to give you all a little bit of background. So this case came out of Massachusetts, and it was dismissed September 30th, 2022 on PLCAA, which, if you listen to the oral arguments, is now PLCAA.
Oh God, I hate it so much. They all called it placa.
Waka PLCAA.
I hate it.
All right, but so this case got dismissed at the district court level, went up to the First Circuit Court of Appeals. They said, hey, guess what? They reversed the lower court. We need to evaluate whether the two kind of issues here sidestep the PLCAA. Is this something that the PLCAA contemplated? That's an aiding and abetting an approximate cause. And it was pretty fascinating. And we'll talk about our predictions on this because I think it's good news.
Yeah, well, so we've got the Protection of Lawful Commerce and Arms Act. We've talked about many times on this channel. I won't do a full recap here, but passed in 2005 with the intent that it should protect firearm manufacturers from frivolous suit. Those frivolous suits being lawsuits filed when some bad guy does something bad with a firearm. So we've got Mexico going, man, you know what? Our bad guys sure do use a lot of guns. That must be America's problem. Let's sue Smith & Wesson, amongst others. And so we have this bonkers lawsuit, which for some reason the First Circuit has revived and is now up with the Supreme Court 3+ years after filing. So what's the deal with the... So I sound like Jerry Seinfeld. What's the deal with the PLCAA? Like, why are we here? What are we even talking about?
Well, so this is the idea, right? Hey, somebody gets drunk and drives a Ford. Is Ford on the hook for this stuff? And there are some analogies to alcohol consumption that the parties make that I think is a really good analogy. But really, what we're saying is, hey, apart from like manufacturer's defects, think like firearm blows up in your hand. Think, they say breaking contracts, or let's say they, enter into some kind of contract, breach your contract. This isn't what the PLCAA is designed for. But if these firearms are used as intended, or they're delivered, they work the way they're supposed to work, hey, guess what? These manufacturers aren't supposed to be on the hook for this stuff. There's one kind of caveat exception for this, which deals with kind of deceptive advertising. That was built into the law. And so this is kind of how Mexico gets their foot in the door, but ultimately they're trying to sidestep the entire issue of the PLCAA.
Right. So the exception is you have violated a statute. And that statutory violation means that all of a sudden, the PLCAA no longer applies. Lawsuit can move forward. So we've seen this happen recently. Plaintiffs alleging violations of like fraudulent marketing statutes on the state level, Deceptive Trade Practices Act statutes on the state level. And here we've got Mexico saying, well, you aided and abetted all of the bad stuff that happened from here that got the firearms in the hands of our cartels and caused all of these criminal acts. So you've got the allegation is that Smith & Wesson essentially aided and abetted. And if they aided and abetted, then we have to see that there was some sort of proximate cause between their actions and the ultimate harm, which again is just it's just out of this world. So I think we touched we touch on aiding and abetting first before proximate cause, because they're both equally stupid. So we've got this idea from Mexico that because of the nature of ATF traces, Smith and Wesson knew who the rogue FFL dealers were, and as such should have stopped selling firearms to them, which as far as I know, has never been alleged in the history of ever. But
Yeah, the parties kind of bring that up too.
yeah, so like idea being, you find a firearm next to a dead body in Mexico. The ATF goes, "Hey, Smith and Wesson, you produced this firearm. Tell us where it went from here," because that's how your ATF traces work. And like idea that like Smith and Wesson committed a knowing violation of this statute because like they should have been like categorizing which dealers were ultimately the straw men going to the cartels, which I mean, how do you even prove that? How do you even prove it's happening through straw man purchases as opposed to through robbery, as opposed to there's a million problems with that. But so problem one is Smith and Wesson, really, they're supposed to know. They're supposed to know.
Yeah,
It's
well,
ridiculous.
well, and so that's where we're saying, all right, this aiding and abetting law is being violated, therefore they don't get the protections of the PLCAA. Well, that's not the end of the story. The kind of second component to this is proximate cause. And I think we have a fantastic clip here from Justice Thomas in questioning on this. But really what you're saying is, and we all do this, this is kind of how American law works, common law works. We all owe duties to each other, and some we have very high duties. You're an invited guest on my property. I'm your doctor. Maybe we have a higher standard of care.
I'm your employer.
Right.
Very high standard, very high duty, right?
Compared to like complete stranger you've never met before, guess what? You have a pretty minimal duty to that person, but you still have some level of care to the people around you. And so, ultimately what they're saying is you had this duty of care, you broke your duty of care, you fell below that standard, and then the proximate effect of this was a harm to us. Now, proximate cause is usually like but for, this nexus between the two things that connects the negligent act and then the harm to the person. And there are so many breaks in the chain of, hey, you are directly tied to this. I cannot fathom how they would ever be able to prove this.
No. Here, let's run the clip.
Yeah. This is Justice Thomas questioning on this very issue.
Justice Thomas?
Mr. Francisco, in direct sales, there was exactly that, a direct sale to a doctor. And the seller worked closely with the doctor to work around the limitations. In your brief, you summarized the chain that you've mentioned or alluded to a number of times. Would you just list the chain for our benefit?
Sure. Starts out with a licensed manufacturer, a manufacturer that the federal government says is allowed to make firearms. It then distributes its legal firearms to licensed distributors who the federal government says are allowed to distribute them. They then sell to licensed retailers that the federal government says are allowed to retail. Those retailers, some very small percentage of them, unknown number, but some small percentage of them, transfer those firearms illegally to straw purchasers. The straw purchaser then hands it over to the actual purchaser. You then have a smuggle across an international border, yet another violation of law. The smuggler then presumably gives it to the cartels who are illegally possessing the firearm in Mexico under Mexican law, as my friends have described it. Then the Mexican cartels engage in murder and mayhem against the good people of Mexico, all of which in turn causes the Mexican government to have to spend money to respond to that murder and mayhem. With respect, there's not a single case in history that comes close to that. They don't even cite cases that find a manufacturer, I think, ever liable for the unlawful criminal misuse of its products, other than the cases that PLCAA was meant to prohibit, and perhaps other than the Avis case, the Florida Supreme Court case. But they certainly don't cite anything that comes close to that chain of causation, which is more extreme than the cases that PLCAA was meant to prohibit.
So, I mean, just look at that. How many interventions along the way How many degrees from Kevin Bacon almost, right? How many different criminal acts happen along the way that it would have to be foreseeable to Smith and Wesson to know, to put them on notice, to take some kind of corrective action? It's a ridiculous argument.
It's a ridiculous argument. And then there's all sorts of other ridiculousnesses that come in here from the, I mean, and I will say, both lawyers, I think, did really good jobs.
Yeah, Smith and Wesson's lawyer, I think, did a better job.
Well, but we agree with him.
Sure.
We're gonna
All right,
think
I'm a
he
little
did better
biased.
job. But the lawyer for Mexico, she did a very, very competent job as well. I happen to disagree with her, but they were both extraordinarily competent lawyers. But yeah, there were these other weird arguments that like Smith and Wesson's lawyer pointed out in his rebuttal portion, where basically like Mexico's alleging that because Smith and Wesson has a firearm with a Spanish name, that like that's like a wink and a nod to the cartels, to like, which is so offensive.
Yeah, it's silly.
So offensive. Can you imagine being like, well, if you market something in Spanish, it's obviously meant for criminals? No, that's just ridiculous. I mean, it's just wild that they would be saying that.
It's the bigotry of low expectations.
I mean, and the anti-gunners are like, it's like, no, absolutely not. And like Smith and Wesson like designs its firearms in a way that you can obscure the serial number more easily, which is like, no. Like I carry a Smith and Wesson.
Yeah,
I don't see any difference.
So aiding and abetting, there's no precedent for this.
No.
And this proximate cause, I don't know how we get there, but
no.
What's the PLCAA all about? It's about not running gun manufacturers out of business for simply engaging in business, right?
Right.
And so the idea is also, I mean, this case was originally dismissed September 30th, 2022. We're at the Supreme Court right now in 2025. We're talking about potentially, if this case were to get sent back to the court, remanded to litigate, hey, merits of this cause, let's figure it out and try again. I mean, this thing could go on for 2, 3, 4, 5 more years.
Oh, yeah.
And I mean, defending this suit, I mean, every single month is probably costing tens of thousands of dollars. I mean,
more, I would imagine.
So that's the idea behind the PLCAA. Hey, guess what? And this isn't even a judgment against Smith and Wesson. Like they haven't even assigned fault to Smith and Wesson. This is just responding to the lawsuit at this point. So you see why this is so important, because we don't want, folks who are operating legally, making firearms, that's American as apple pie, getting run out of business on frivolous lawsuits.
Right. So I will say lawyers who are qualified to argue in front of the Supreme Court of the United States are the most expensive lawyers you are ever going to find in the country. So, I mean, they make my fees look laughable. So it's a lot of money. And that's what happens, right? All of these cases that have come before where judges and appellate courts have let people skirt around the PLCAA and let the case proceed forward, they haven't gone to verdict. They haven't gone to trial. They have gotten to the point of the manufacturer saying, okay, well, we've already spent, hundreds of thousands of dollars or more on the defense of this case. What's it going to cost us in nuisance or cost of defense to litigate this fully? Are you willing to take that in settlement amount? Here you go. It's a dollars and cents analysis. Now here, I don't know if we're going to get there because Mexico is asking for $10 billion, $1 billion. So I just
you just need a hairless panther.
I know. Can we have one for the office?
Sure.
But no, in addition to some wild injunctive relief, but like, I mean, I'd assume that they're not willing to take a small, in comparison, settlement. So maybe this one gets fully litigated.
Yeah. So, all right, let's do some crystal ball time. All right. We'll do the first overriding issue. Who do we think wins this?
I think Smith and Wesson wins.
I agree with you on that.
I think that the justices, even the more liberal justices, their questioning indicates that they are on the side of Smith and Wesson, which is crazy to me because this case is I think it's at the 12B6 stage.
Yeah. We had Sotomayor. She tipped her hat. I mean, it looked like she's on the side of most of the conservative justices.
Yeah. And even Jackson, at first I was like, oh gosh, it's so bad. But then even Jackson, when she was questioning the lawyer from Mexico, I was like, oh, okay. I think that she's actually on the side of Smith and Wesson too, which is right. So, I mean, we have
The other surprise was Amy Coney Barrett. She did not seem.
No.
She made it sound like, hey, this still needs to be litigated. Start from scratch.
Yeah, I don't like that. And that's the out. That's the scary part here. The easy out for the justices, should they want to take it, should Richard and I be wrong, is for them to say, well, look, we are at this very early stage. It hasn't been fully litigated. So you know what? It's really no skin off our teeth if we say, sure, you can proceed forward with this because we, the justices of the Supreme Court, will get another bite at the apple later down the road because we're at such an early stage. I mean, that's would be bad precedent and bad public policy, but also it gets them out of a squirrely place if they feel like they're in one.
And it's totally within the realm of possibility.
Totally within the realm of possibility.
All right. But I think they're probably going to issue a decision. I think they're probably going to bring it into this case. Obviously, we can be wrong. It's hard to guess what the Supreme Court's going to do. I guess kind of the next question I have is, do we think it's going to be a broad opinion covering aiding and abetting and this proximate cause? Do we think it's more limited? What do you think?
I think it's more limited. And
yeah, I think so too.
Yeah, apparently. As is Mark Smith, Four Boxes Diner. Shout out.
Yeah, Mark's great.
Much smarter lawyer than we are because we are just criminal law jabronis.
Sure.
But he actually litigates in front of the Supreme Court, or did. So yes, I think that there is a much better chance that we do not get any sort of sweeping, helpful opinion on the PLCAA. We don't get any sort of opinion on proximate cause. We're just looking at aiding and abetting, and
this statute,
they kick it.
Yeah, this statute is not within what was contemplated with the PLCAA.
Right. It's not firearm specific.
It's not firearm specific.
Or it wasn't a knowing violation.
Right.
Right. There's all sorts of things.
But it would be so stinking helpful if we get some guardrails on proximate cause, because,
wouldn't it?
Unlike, someone giving somebody like we were talking about Dram Shop. That's when, bar overserves somebody, they go and crash their car, hurt themselves, hurt somebody else. Is this bar responsible? Well, I'm just using that as an example for a moment because you can kind of draw a little bit of a line between
very similar.
Yeah, very similar. But you see how short that window is and how straight that line is. And guess what? Those cases get litigated all the time. We are talking about a crazy winding path with criminals all along it with so many different violations. How could this be foreseeable for any gun manufacturer?
Exactly. So the alcohol thing, this actually, because to me, that is a great comparison on the pro-gun side, pro-guns, pro-Smith & Wesson side, is to say, look, you sell alcohol knowing that people can buy your product and then do stuff with it.
Misuse it.
Yeah, that they misuse it, they hurt themselves, they hurt other people. But that's not on Budweiser, right? That's not on Miller Coors to figure that out. It's on, some personal responsibility up in this bitch, please. And so we've got that kind of idea, but it was coming from Mexico. It was coming from the opposite side, but they were like, well, you see, if Budweiser sees that all of their sales are happening in a place where it's all underage drinking, then they know. And it's like, no.
I think that spooked the judges on the left a little bit.
I think it did.
Yeah.
So, really, it just is, it's totally ridiculous. And then I have one more thing to say.
Sure, let's hear it.
Okay. All right. The other injunctive
Yeah,
relief,
the injunctions, I was going to say.
Oh my God, the things that Mexico is asking for, Richard.
They want to rewrite American gun law.
They do. They want things that you could not do through executive order. They want things that the Congress could never get through.
Or if they got through, would be found unconstitutional.
Yes. Mexico does not, what kind of public policy precedent are we setting if we even let them proceed forward in a case where they're like, hey, ultimately, we want sweeping changes to the gun law of another sovereign nation that we have nothing, what's to stop what's to stop China from coming in and being like, here's a lawsuit to change your laws in a way that's going to make,
lawsuit.
Oh, can you do that on YouTube? Oof. So anyway, but it's just, they want assault weapons bans, and they want to limit the number of firearms you can buy, and they want
magazine capacity stuff.
Yes. It's just the sort of things that they are asking for is just, they want more stringent background checks. It's that's against the rules.
Yeah.
You're not allowed to do that.
So I'll say cautiously optimistic. I think we're going to see this come down on the side of Smith & Wesson.
I think so.
Do we get a broad opinion? I would like that. Do we get it? Probably not. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And if you can make Lobby Day in Austin, Texas on March 11th, don't forget to go to texas.gunowners.org, register, get yourself a free bus, get out there. I'll see you there. Until next time, we're the Armed Attorneys.